Okay.
Dexter says he's waiting for the webinar.
I know. Casting, so everybody should start trickling in. And so I'm going to, should I go live on Facebook now or at 11 when we start?
I think you should go now so I can get the watch party going, and
Oh, okay.
we'll behave. We won't make goofy faces at each other.
Okay, so let's see. I can share it on a page I manage.
So I'd love to see if the notifications start popping up.
I might. Okay, I tried to do it on a page that I manage, but let's see. Hi, everyone. I'm trying to get us on Facebook Live, so just bear with me, okay? How do I check that my screen?
It says it's now streaming live on Facebook.
Oh, it is?
We got a prompt. I don't see a notification here, but.
Well, it's, let's see if we're live now. Are we?
Look on the upper left-hand side of the screen.
It does, it says that we're live. And so now I'm going to, oh, I think it's a recording. Let me see. Dexter or anybody who is on our board who's joining us today, can you please check out our Facebook page and see if we're on live? I can't really tell on my end, but it looks like it is. And I know we have, oh, quite a few people on. Thanks for coming on early, guys. I really appreciate it. And please bear with me because it's our first time using Zoom for the webinar portion, and we're trying to go live on Facebook, which I believe we are. Good morning, Cheryl. Okay. Well, I do have this recorded now, and so it does say that we're live, so I'm going to assume that we are live. And let's wait it for a few minutes. Let's give it a few minutes before we get started. I know we're just a minute away from 11. Okay. I'm gonna put our links in our chat box. So, all right, okay. I do see quite a few people on. So hey everyone, thanks for joining us today. Let's give it a few more minutes before we get started. So in the meantime, feel free to get our chat box rolling. You could let us know where you're logging in from today. Oh. Let's see. Okay, perfect. All right. Dexter, I see some familiar names. Dave, is my screen full screened, or can you see some things blocking? Because I have our chat box kind of open. Do you see a complete full screen for you?
I do. I do.
Okay, great. Perfect. All right. Welcome, Diana. Welcome, Joyce, Lucy, Mary, Kay's on, Ronald's on, Rosa's on. Hey, Rosa. Alice is on. Wilson, our president, is on. Welcome. Happy Friday for sure. Okay. So before we get started, let's take care of some housekeeping items. I always like to do this in the beginning of our webinar. And that is, if you take a look at your menu bar, I'm sure many of us are already familiar with Zoom, but there is a separate Q&A section, chat box, as well as the regular chat box that you can see my links coming on. So I'll paste the links on again in case there's a few people just as they come on, because I don't think you can see previous chats if you come on as you come on. So I'll continue to post that, and that way you have the chance to go ahead and join us on Facebook, and then take our survey if you haven't already on Google. That just gives us the chance to get to know you a little bit better and how to provide, you know, a topic that you guys are all interested in moving forward. And also our Instagram, feel free to join us there as well. And we do have a WeChat. If you wanted to add us on WeChat, there's some sharing of deals and, you know, coming listings as well as coming soon. So if you're interested in taking a look at that, go ahead and add us on WeChat. And let's see here. Should we give it a few more minutes? Let's see. We have actually quite a few attendees on. So I think we can get started. What do you think, Dave?
I'm ready to go whenever you are.
Okay, perfect. So let's get started. Welcome to our CAREA WebEx, or I'm sorry, not WebEx. We've been doing WebEx, but this is our Zoom speaker event on the COVID-19 eviction, tenant eviction, and rent deferral moratoriums with Dave Bonaccorsi. So for those of you who don't know me, I am a commercial real estate broker with GD Commercial and part of this year's board of directors for CAREA, and I'm honored to be hosting today's event for one of our own advisory board members, David Bonaccorsi, with Bernard Balgley and Bonaccorsi LLP. So David will be speaking on COVID-19 tenant eviction and rent deferral moratoriums for a very short 1-hour event. And I know it's tough right now with not just COVID, but now with our fires and the smoke in the Bay Area, and also our kids back in school for virtual learning. I know it's kind of crazy everywhere. So I wanted to take this time to really thank you for joining us today and being here with the mindset of education, learning, and self-growth together. So to briefly introduce us, the Chinese American Real Estate Association is a nonprofit organization established to promote the social and economic well-being of our associates and further the professional image of Asian Americans who are engaged in the field of real estate. We warmly welcome you to join and become one of our members. And for details, please go ahead and check out our website, which is carea.org. This event is being recorded, and for some of our members who can't make it today, so this can also be found on YouTube, as well as our CAREA website. You will also be receiving an email from us with the recording, I believe with a YouTube link the next day, and I believe we are live currently, so that's very exciting. So let's start by welcoming David Bonaccorsi, a partner with Bernard Balgley and Bonaccorsi LLP, a premier Bay Area law firm representing civil litigation, transactional law, including representing commercial and residential landlords and commercial tenants. Let's welcome Dave. So I'm going to pass the control over to you.
Good morning, Michelle. Let's see if we have it here. Do I have control? I don't know if I do yet. We'll see. There we go. And that's your wonderful executive officers and our board of directors for CAREA, and I've been honored to be a legal advisor for the Chinese American Real Estate Association for now going on 12 years, and I'm very excited at the growth of the organization. And we will go right into our presentation, but this is kind of an interesting bookend. The last time I did a presentation was on AB 1482, and that was over at the Metro Crossing at Toll Brothers in February, right before our pandemic. Little do we know we would be having COVID affect all of us, and it's directly impacted landlord-tenant law in California. And just as a brief overview before I go into the presentation, for those that are not necessarily familiar with landlord-tenant law, historically that has been governed at the state level. In terms of how you try to terminate a lease, the rules that are required in order to do so. And there are certain areas where the cities, like in Berkeley and Santa Monica and Malibu, have enacted very stringent rent control laws that cap rents. But in terms of how and when tenants can be evicted, that's been really at the state level. Well, that all changed on March 4th. When Governor Newsom declared a state of emergency due to COVID-19. That state of emergency remains in effect, and it will remain in effect as far as we know for the foreseeable future. Shortly thereafter, on March 16th, he, with his increased powers, enacted Executive Order N2820. And this opened the field for counties and cities to step in and enact local regulations that would under certain circumstances, limit the ability of landlords and tenants, landlords to evict tenants based on COVID-related reasons. And then that order has been in effect, allowing counties and cities to enact regulations all the way through September 30th. So as we go through the discussion towards the end, one of the deadlines that's coming up is September 30th and what will happen after that point. Michelle, I'm trying to see if I can move my PowerPoint here. Right now, there we have some control again. So let's see if we can move it. So the floodgates open for moratoria and ordinances up and down the state. Alameda and San Mateo County enacted commercial moratoriums involving commercial leases only in the unincorporated areas. Alameda County has now enacted, since June, a residential ordinance that applies not only to the unincorporated areas, but to all of the cities in Alameda County. And Santa Clara County is the same. Both would allow for cities to regulate or do regulate if it's more tenant protective. And then these are some of the cities that enacted rent deferrals. I should add that as part of the PowerPoint today and as part of the presentation, we will make available this PowerPoint so you can see it at your leisure. There's a lot of material to cover in an hour, and I want to make sure I have some time left for your questions. So as we went through chronologically, one of the things that came in that really had a significant impact on landlord-tenant evictions was the California Judicial Council. California Judicial Council is headed by the Chief Justice of the Supreme Court. Even attorneys are not very familiar with what the CJC does, but it enacted on April 6th an emergency order that prohibited all evictions, whether COVID-related or not, for all commercial and residential leases. There was limited exceptions for public health and safety, and when it was initially enacted, it was going to stay in effect until 90 days after the state of emergency was lifted. But just last week, or 2 weeks ago on August 13th, the CJC lifted and changed its own emergency orders, and it is rescinding it as of September 1st. So in areas of the state where there is no eviction moratorium in place, we may begin to see some evictions happening in September. But what happens after September? I'm going to talk about some other legislation that's in the works, and so we'll have to see. What do eviction bans do? And these so far have been focused on local initiative, county initiatives. Typically, they can tenants can defer rent if they're eligible. They cannot be terminated. The leases are not terminated as long as there's a COVID emergency in place, as long as the moratoriums are in place. And they create two classes of tenants: tenants who can defer rent, and ineligible tenants who don't qualify or don't exercise their rights under COVID who can be served with pre-litigation termination notices. The CAG, California Judicial Council, hold on all unlawful detainer complaints, as I said, will lift on September 1st. So these ordinances will become important to ensure that some subclass of tenants can remain in their leases without paying rent if they are subject to COVID issues. And the reason why, just kind of understanding why is this happening, it's not to say, let's pick winners and losers in this economy. I'm sure if you're a landlord, you're feeling like you're losing in the struggle between landlord rights and tenant rights. But the public policy reason is that the state wants to limit dislocation or displacement of tenants to reduce community spread of COVID. If you have massive relocation, massive terminations, people are going to be moving around, congregating, and spreading the virus. So that's been the real major policy push. Michelle, if you could give me, there we go. It takes a little bit of time for me to get control of the PowerPoint again. So let's go to the next one. Again, if you're in a county that doesn't have an eviction ban for residential or commercial tenants, you can serve pre-litigation termination notices. And there's, however, a waiver of your 3-day notice that you give to tenants if you accept rent thereafter. So before, when I was giving this proceeding, I said, well, why are you going to start this process if you have the rules in place at the state level where you can't go in and evict anybody? But again, with the lifting after September 1st of the statewide order, unless there's other regulations or rules that come in place, there may be more tenants that may be subject to eviction after September 1st. There are a series of rules that apply. For example, in Alameda County, there was county rules, and then there's been various cities that had enacted eviction ban moratoriums for residential tenants. So if you're a landlord, you really need to answer these questions to figure out which rules apply. Does the county have an eviction ban and allow rent deferral? If so, and the property is an unincorporated part of the county, certainly the county rules will apply. If the city has an eviction ban and rent deferral, but there's no county ban, follow the city moratorium or ordinance. In cities and in counties which both have eviction bans that allow rent deferrals, such as in Santa Clara County and San Mateo County for residential leases, the rules that favor the tenant the most apply. So in Santa Clara County, the rules for residential tenants in San Jose are more tenant protective. In Alameda County, the county rule applies unless the city opts out for residential tenants, but none is likely to do it in Fremont, Hayward, any of the cities in Alameda County, because the rules at the county level, which we can go into later, are so tenant protective that no city in Alameda County has enacted anything that comes close. In Contra Costa County, they've done a different approach, which I think is pretty reasonable, and it's easier for a landlord to follow and easier, frankly, for tenants to follow. There is a county-wide ordinance for residential eviction bans based on COVID, but if there's a city ordinance, just follow the city ordinance. You don't have to compare and contrast, figure out which is more tenant protective. So in Concord, there is also a residential eviction ban. Just follow the Concord rules and don't worry about Contra Costa County. Same for eligible commercial tenants. If you have a commercial lease, you need to answer these questions. Does the county have an eviction ban and allow rent deferral? If so, and the property is in an unincorporated part of the county rules apply. Does the city have an eviction ban and allow rent deferral? Well, then you have to go and start this balancing act. In Santa Clara County, it's whatever rules favor the tenant the most. In Alameda and San Mateo counties, only if the city has an ordinance, follow the city ordinance, as Alameda County's commercial ordinance only applies to unincorporated areas, and similarly with San Mateo County. In Contra Costa County, again, the same balancing. If the city has an ordinance, follow the city ordinance. You don't have to compare and contrast with the county ordinance. The Santa Clara County moratorium is a typical moratorium and it applies both to small businesses and residential tenants. how does somebody as a tenant claim that they have COVID affected a situation where they can't pay rent in whole or part? They have to document whether they've had a job loss or they've been laid off, loss of compensable work hours, they've been in a business that's been closed, or if you're a business person, show a substantial decrease in business income due to consumer demand or reduction of hours demand. So for example, if you've been in a restaurant and you've been in shelter-in-place orders where you can't serve inside, it's relatively easy to show that your revenues will have been reduced because of those closure rules. Also, if you had to miss work for a homebound school-age child or other loss of income for COVID-19 related reasons, you've documented it. There's also another category if sadly you've suffered from COVID or somebody in your immediate family has, and your insurance doesn't cover it and you have enormous medical expenses. That's another way of seeking relief if you're a tenant. What is considered a small business? And it differs depending upon the ordinance. In Santa Clara County, you have to look at the Small Business Administration table of size standards, which goes across various industries. And so a small business, in my opinion, can be quite large, as much as having revenues of $25 million a year and having over 100 employees. Fremont, by comparison, had a more practical approach to really define what a small business is, as any business in Fremont that has $8 million or less in gross revenues per year, so that you don't have to go to a table and index and figure out what the Small Business Administration thinks is a small business. Again, if you qualify as a tenant, then you get rent deferral for up to 120 days after the current August 31st, 2020 expiration date. So we're coming up against a hard deadline in Santa Clara County that may end the COVID relief period. But next Tuesday, follow what happens at the County Board of Supervisors. They're going to be considering extending that. The notice of termination with tenants' rights under ordinance and emergency rental assistance with an approved Santa Clara County Office of Supportive Housing form. So when you do, if you're a landlord, if you're advising landlords, not only do you have to give out an appropriate notice if somebody's behind rent, but you have to include the tenant's rights under the ordinance so that they invoke it. And again, if the tenant becomes eligible and can document it or says that they are eligible, the owner cannot proceed with an eviction. The tenants can also rely on just cause defenses under AB 1482 or any of the local just cause ordinance as additional reasons why they shouldn't be evicted. In Santa Clara County, they've been quite helpful to tenants and landlords because they've actually provided various forms that you must use, but at least you know what the forms are. And so there's a landlord tenant notice to tenant that you must provide as part of your 3-day notice, and then the tenant in turn has a form which they can return to the landlord to say, hey, I'm COVID eligible. Here is the requirement of statement of reasons. This is a sample moratorium form you can find on the Santa Clara County website. You go to the housing department and these forms are down, you can download these forms. And this is the form a landlord trying to evict a tenant would have to show the tenant. And it really summarizes what the ordinance is in Santa Clara County for both residential tenants and small business. The landlord has to give a reason for the termination, has to provide a notice of tenants' rights, and then there's a notice of emergency rental assistance programs that the tenant might take advantage of. Here is the requirement statements. Again, something that the landlord has to provide. And if you look at the right-hand side, there is a frequently asked questions on the county website, and it gives you the link. And then the emergency rental assistance programs that are also available, that are potentially available to tenants to reduce the liability. Let me just step back as I'm showing you these forms and going through various rules. Let me give a kind of a practical context to what is going on. The moratoriums that exist currently, with one significant exception, are really about deferring rent and not forgiving rent and still making rent an obligation at some future time. So in Fremont, for example, under the commercial moratorium, they impose upon the commercial small business owner to pay as much as he can or she can, and to mitigate his or her loss. So if you're a restaurant, to have curbside pickup, to have delivery, use Uber and DoorDash and other means to get your restaurant selling items that you would normally sell indoors. You have to show those efforts to mitigate. But on the other hand, there is a benefit to the landlord and tenant, because whatever the hole is you're digging in terms of deferring rent, it's less of a hole after these moratoriums are lifted. If you have to pay $9,000 or $10,000 a month as a small business person, if you pay something, then you're not going to be in a situation where you can never catch up. 120 days comes up quickly. So if you're going to be in Santa Clara County as a tenant and you've been deferring rent since March, that's 5 months worth of rent. That's $15,000. Somehow in the 120 days after the moratorium is lifted, you'd have to pay that $3,000 of current rent to stay current, and somehow in that 120-day period make up the $15,000. That's going to be a huge lift, and it's only deferring the time where landlords, if they insist on it, collecting every last dollar of rent on a timely basis, will be clogging up the courts with evictions, except as I will describe towards the end here, some state legislation that may come into effect. Here's the return from the tenant back to the notice saying in Santa Clara County, I'm subject to COVID relief. And it really has your name, your street address, and then if you go here, the COVID impact, my income has been substantially negatively impacted by COVID, and you check off all of the boxes. And then this is the kind of documentation that you should provide the landlord. There's an interesting question here. It says, is it attached, yes or no? There's really no affirmative duty for the tenant to actually document in real time, but they would have to show it at some point during the unlawful detainer proceeding. So if you're a landlord, I would cajole and encourage, but not insist upon documentation. If you're the tenant, you really should show the documentation now to eliminate any question. These ordinances typically have a provision in them that the information, particularly with small business, you're turning over bank statements, but even in a residential landlord-tenant context, if you're showing your financials or that you've been laid off, all of that information is supposed to be confidential. And really, after this COVID period is over and you're current, if you're a tenant, you should ask for it back. If you're a landlord, you should provide it back to the tenant. It's intended to be a temporary reprieve. But here is where I've been giving these webinars since April 9th. And really from April 9th all the way through, I would say, July, it's been relatively the same. The focus has been on local eviction moratoriums. We can have, there's now more uncertainty in what's going to happen in the next 6 to 8 weeks than there ever has been since COVID hit us back in March. And why is that? These are some of the reasons. On September 1st, as I mentioned, the eviction ban by the state California Judicial Council is lifted. Up until that point, I could go through all these moratoriums and say, well, they're nice, invoke them. But even if you goof or a landlord would want to try to evict a tenant, there was nothing you could do because of the statewide emergency order. That is now lifted. So now the moratoriums will become increasingly important if they're in effect, and in areas where there's no moratoriums, unless there's statewide relief. As I mentioned earlier, you're going to see landlords beginning the process of evicting tenants. On September 30th, the governor is going to lift his, well, we don't know whether he's going to lift it, but the governor's executive order authorizing these local eviction bans terminates. So again, from March, when he initially enacted this executive order, all the way up to September 30th, He has said to counties and cities, you can go ahead and enact, renew, modify leases. Well, there's an interesting tension that's forming in the law that may become more and more apparent if the governor lifts his eviction bans. In Santa Clara County, they've taken that statewide executive order seriously in interpreting it in this way, that once the governor lifts his executive order, if he does so, the county takes the position, and I think it's the appropriate position, that their ability to regulate COVID relief for tenants ends. It only goes as far as the executive order. They can't reach beyond that date to try to continue to institute eviction bans and extend COVID relief. So I assume on Santa Clara County, what they're going to do on the agenda, there will be on August 25th, next Tuesday, to extend the August 31st deadline only to September 30th. And so for one more month, people can invoke COVID relief, and tenants, commercial and residential in Santa Clara County, if they are eligible, will not be subject to an eviction proceeding. Similarly, in San Jose, they had an August 31st deadline for their COVID moratorium. They're going to be extending it. We don't know how far. Well, they on Tuesday extended to September 30th. Alameda County has been the most tenant protective and has essentially taken the opportunity to regulate and run with it. So even before September 30th, back in June, they introduced an ordinance that, and then have extended it since in late July, that their deadline extends 60 days after December 30th, or the county health order, whichever is later. Well, that may be subject to challenge. If you have the governor say the counties can't regulate in this area after September 30th, and I'm not extending it further, will on October 1st, a landlord try to evict a tenant that doesn't pay rent and say that the county's ordinance is unenforceable, it's void because it's purporting to regulate in an area where the governor's taken away the authority to regulate. That will be something to watch. But again, as we talk in the next slide, this may be all preempted by some state law. The Alameda County aggressively has extended writs of possession prohibitions until December 31st. Well, what's a writ of possession? You as a landlord need to get a judgment, whether by default or after a trial, from the court saying that you've recovered possession. If the tenant doesn't vacate voluntarily at that point, you go through a writ process where you get the county sheriff to go out and forcibly evict the tenant. Well, Alameda County has extended that deadline to December 31st. Well, what does that mean? That means that even if you happened in February to get a judgment against a tenant, and right as the sheriff was coming out, they suspended writs because of COVID, you could be waiting until next year with a tenant sitting in there for 9 months, 10 months, 11 months, not having paid anything in default and as a judgment, and you still can't recover possession. The Fremont Commercial Moratorium, again, is very favorable to commercial tenants, and it purports to go beyond September 30th with the governor's executive order, and will go as far as 30 days after our local emergency is lifted. So these are the future developments. These are the coming attractions. There are 2 bills that are in the state legislature that we should all follow carefully to see what happens. And I could give an hour presentation on each of these, and so I'm touching them with a very light stroke. They're not law yet. But Senate Bill 1410 has passed the Senate and has gone to the Assembly. It's a voluntary agreement between landlords and tenants. It authorizes but does not require these agreements. They're considered a landlord-tenant COVID-19 relief agreement. And if the agreement is entered into, then you have to follow the statutory requirements of SB 1410 if it becomes law, which would prohibit evictions during the state of emergency, as long as the state of emergency lasts, and it allows the tenant to pay deferred rent that it's not paying to the landlord during this COVID time for a 10-year period from January 2024 to January 2034 for 10 years. But it doesn't go to the landlord at that point, it goes to the Franchise Tax Board. And the landlord in turn then can begin getting tax credits for the unpaid deferred rent that is now essentially a consumer debt that's paid to the franchise tax board for whatever deferred rent it allowed its tenants to defer. And so it gets tax credits. And one of the interesting things, if this passes, is that it allows landlords to sell their tax credits to third parties. So you may begin to see this market of people selling tax credits. That would be an interesting business model. So not only, if you're going to enter into this agreement, I would recommend not only have an attorney review it, but also a CPA or an emergency somebody that's involved, somebody that's more than a bookkeeper that really can understand the tax implications of this. State legislature has also is considering AB 1436. It started in the Assembly. It's passed the Assembly. It's now gone through the Senate. We go through committees. It passed the Senate Judiciary Committee last Friday. It's going to the Senate floor. This is mandatory if it passes and goes into law. And if a tenant says, I've got COVID-19 related financial distress, it will bar evictions for 15 months or after the earlier 15 months or the state of emergency lifted on April 1st, 2021. So right now, April 1st, 2021 would look like the date that these eviction bans would remain in place. And that would be statewide. So even if your local moratorium expires, like in Santa Clara County, if they only go to September 30th and the executive order doesn't extend it, in theory, AB 1436 will kick in. Landlord is given certain benefits. They're able to defer up to 180 days and ask for another 180 days for a 360-day mortgage forbearance for that period of time for the rent that is being deferred. Now, let's go to the next page because there's some moving targets here. Again, I want to talk about September 1st. California Judicial Council lifts the eviction ban and governor's executive order allowing local eviction bans on September 30th. Think of those dates. But AB 1436 and SB 1410 must pass both the Assembly and the Senate by August 31st, 2020, and must be printed up by Friday of next week because the legislature needs 3 days. If it doesn't happen by that date, then the bill will die and it won't come into law at all. Governor has until September 30th to sign any new bills into law. So you may hear headlines that these bills have passed. Governor may have 30 days until September 30th to sign. So there's two things that can happen here. One is AB 1436 and SB 1410 don't become law immediately unless they receive 2/3 support and go into effect immediately. So you could have the laws passed, signed into law, but if they don't have 2/3 support, they won't go into effect until January 1st. What would happen then? Likely the governor, in my opinion, would extend the abilities of local moratoriums to remain in effect until January 1st of next year. And very early on in this COVID period, he had enacted a statewide residential ban, which actually expired on July 28th. He might reenact that. So I really do think that the likely scenario is that these eviction bans, particularly for residential tenants, are going to be in effect at least through April of 2021, whether through local moratorium, through governor's executive order, or through AB 1436 and SB 1410. So I just had this here as a sample payment plan agreement that you can work out. One of the things under AB 1436 I thought was interesting was for all of this deferred rent that gets repaid, that they encourage landlords and tenants to utilize various mediation services, including new attorneys that have just graduated from law school, the district attorney's office, various people to work out agreements to allow for repayment. So at this point, I want to honor the opportunity here. Michelle, it's 11:35. I did go through it quickly because I want to honor the 1 hour time frame and start taking questions. I can't hear you yet. You're going to have to unmute.
Oh, I'm on mute. Sorry, guys.
Thank you.
Of course. Thank you so much, Dave, for that wonderful presentation and all the great information. I know we have quite a few questions coming in on the chat box on my side. I'll also check on the Q&A side. So if you do have questions, please open up your Q&A box and then type in your questions from there. Dave usually gets quite a few questions regarding this topic, but also like Dave mentioned, I want to be very respectful for everybody's time. We're just at the 36-minute mark, so we have about 20 minutes or so, 25 minutes or so for questions. And if Dave is gracious, he usually spends a little bit more time with us, but we'll have it recorded. If anybody has to leave, feel free to hop off, or let us know in the chat box if you want specific questions answered. This will be recorded and will be sent out, so just rest assured that your question will be answered. So we'll go ahead and jump right into our Q&A section. April is asking, can the landlord sell property while a tenant is living in the property? And is the tenant obligated to cooperate on selling the property with proper protection?
Well, the answer is yes, the landlord can sell property, but this is a real dilemma during these eviction bans. There's no mechanism by which you can get the tenant to leave. And in fact, one of the things that was very problematic about AB 1436, because I've been, of two minds about whether you can have cash for keys and try to induce people to leave early, that those agreements would be considered unenforceable if AB 1436 passes. So it's a dicey area where they're really trying to enforce tenants remaining in place. The only thing I would suggest is, in that circumstance, is that the market would be shrunk to perhaps investors as opposed to owner-occupiers as a buyer contingent that they would take subject to this lease. There might be a markdown in the sales price because you're taking a tenant that may or may not be paying rent. So it creates a great deal of uncertainty if you're buying this for investment property. And so there is nothing that you can coercively do to remove a tenant if the legislation goes into effect. Now, again, everything depends upon where you are. If you're in Bakersfield and it's September 2nd and AB 1436 doesn't pass, then you might be able to go forward. But if you're in my focus really here is Bay Area centric, where these moratoriums are in place. And my belief that even statewide, the governor is going to fill the gap, if there are any gaps, and try to prevent evictions of tenants.
Awesome. Thank you, Dave. One other question that we have is, at what point would you need to engage an attorney, in your opinion? I know you might be trying not to be biased here, David.
No, I was going to joke, always at every point along the process. But no, seriously, I would think that at any point before you even consider doing a notice of termination, I've got, and I've been very thankful of these calls I've got from people that will see it or see my name, and then they'll call me and say, well, I've got a tenant and he's not paying rent. Can I evict him? And I've said, well, I've just given a 1-hour seminar on why you can't. And then and then it goes click, and they don't call back. And so I'm concerned at that point that they're trying, that some people are going to try to engage in self-help, which could get them in real trouble. So I would think that you would certainly need an attorney to advise you as to how properly to make sure that the tenant is invoking their rights under a local moratorium. If you're going to be a landlord and try to take advantage of SB 1410, you would certainly want to have a lawyer look at that agreement, because it's very statutorily defined. And again, if you're trying to do something on the cheap, oh, I've got this, no low press, or I can pull down this old 60 notice I used 2 years ago, invariably you're not going to do it. Even if you have the right to go to court, you're going to do it wrong because you're not including all the notices of termination. To give you an example of how silly it is, how layered it is, where in some instances, I think the counties are really trying to stack the deck against landlords unfairly, is that in Alameda County, if you ever got to the point where you gave a notice of termination, you're supposed to provide the local ordinance of the city that you're in if they have a local moratorium. So if you're in Fremont, you'd have to give a notice of termination with a copy of the county ordinance and the Fremont ordinance. But I just told you, and everybody knows that the Fremont ordinance that bans residential evictions doesn't even apply. But if you miss that piece of paper and you were somehow able to proceed with an eviction, a tenant's attorney would point out that you haven't complied with all of the local regulations and you have to start all over. And it's also important for this reason. Again, I'm going to give the horror story of Alameda County, that if you violate the county ordinance, even unknowingly, and you can say, well, I didn't hire an attorney, I was just doing the best I can, that there are penalties, including misdemeanor violations, that the district attorney can criminally prosecute you for violating. So I'm not just for biased reasons saying consult an attorney, but you're really treading on thin ice here if you try to do it on your own.
Well, it really sounds like the legislation is not making it any easier for landlords. So that's definitely very tough. Okay, so we'll go on to the next question. Rosa's asking, what is your advice for tenants who are collecting rent from other tenants and not paying their landlord? What can a landlord do? I actually know Rosa, and so a little bit background is basically she has a tenant in place, and that tenant is subleasing the house to other roommates. And so the roommates are paying him rent while they're all living there. But, unfortunately, the guy who's on the lease is not paying the landlord after collecting everybody.
Well, has the tenant claimed COVID relief? What county is it in? All these things I would want to know. But as a preface, when you ask the question, what is your advice? I think I didn't have the large disclaimer. I'm not going to give out legal advice. I'm just going to give general principles. Unless I'm retained formally, I don't want to be put in a position where you're relying on anything I'm saying. This is more informational in this regard. One of the possibilities that may exist, and I haven't seen it enacted in the residential context, but I am involved representing a landlord doing this in the commercial context, is that these eviction moratoriums all deal with possession. Okay. They don't deal with rent in isolation. In theory, one could sue for non-payment of rent. In theory, I haven't seen it carried out, but if you know that there was a tenant that was actually collecting rent, you might be able to sue that tenant just in small claims or for breach of contract and not even try to go through the eviction process and see if suddenly the money becomes available to you. So that is something to consider. All of these ordinances, again, start from the premise that we don't want to dislocate tenants. So you say, well, fine. I'm not trying to evict anybody. I can't, and there's these games going on. I'll just go ahead and sue and try to collect it as a consumer debt. And in fact, in Alameda County, it's the only county I've seen, and the only moratorium I've seen this. For all of the rent that's deferred, although it's subject to payment, you have 12 months after the rent was due to pay it. And if you still don't pay it, so for example, you have rent due that you never paid in July. Under the Alameda County ordinance, you have until July 2021 to pay it, and you don't pay it in July 2021, what does the landlord do? He can't send out, or landlord cannot send out a 3-day notice for non-payment of rent. They are required to sue only as a consumer debt. So one of the basic things that's happening right now is that landlord-tenant law has always been based on that bargain between possession and rent. What these moratoriums are doing is really severing that relationship legally, whereas tenants may have possession without ever paying rent or without the landlord ever being able to recover the lease, the lease premises for the short term. So it's a very disruptive time during COVID.
Thank you, Dave. Our next question is from Eunice, and she's asking, is there any relief for landlord from the government? Landlord also have expenses such as property tax, mortgage, etc., while not being able to collect during this period.
SB 1410 is really the first statewide effort to do so. There have been some federal legislation under the original CARES Act that had allowed for some mortgage forbearance for federally backed mortgages. But that expired in late July, and the Senate right now is not in session until after Labor Day, and there may be some federal legislation that addresses forbearance at the federal level. But again, if passed as prologue, it would be limited to federally backed mortgages. The not SB 1410 addresses it in the form of tax credits that kick in as of January 1st, 2024, and you have to register with the Federal Tax Board, and you have to be, we haven't gone into the various categories, you have to be a qualifying landlord to, as a small landlord, as defined by the SB 1410 to qualify it. Under AB 1436, again, there's opportunities for forbearance under that provision for up to potentially 360 days. So it's minimal, it's not equal. I get it. I think that, you know, again, if I were one of the things I had done, we didn't talk about as my background, I was on the city council for a couple of years, so I understand the policy levers that can apply. I think at a state and a national level, if you had rental assistance that went to the tenants to make sure that it went to the landlords, that would be the best way to keep the pump priming in terms of just not disrupting landlords' ability to maintain their property and pay their mortgages on time.
Thank you, Dave. Stanley's asking for clarification on the cash for keys. Can you please clarify what this cash for keys does not work even if the tenant agrees to it?
Yeah, if AB 1436 passes, in my opinion, and again, I'd like to see other analyses of AB 1436, but there is a provision I was reading that any settlement stipulation that runs contrary to the terms of AB 1436 is void against public policy, which means that, in my opinion, if instead of saying, well, deferred rent, you know, somebody that would be eligible, but you say, well, instead of deferring your rent, you can enter into an agreement and I'll give you cash and you just leave and I can try to lease the property to somebody else. That would be, if AB 1436 is the law, in my opinion, my preliminary opinion is that would violate AB 1436. So the tenant could turn around and sue you for breach of quiet enjoyment or, you know, constructive eviction. You can have tort liability, and so the tenant could turn around and have the court rescind that kind of agreement. So you may be having tort liability. One of the other things, this is not the question that was posed, but this reminded me, given that I'm speaking to the Chinese American Real Estate Association, for those of you that speak Mandarin Chinese or speak in another language and do business with tenants in Mandarin Chinese, there is a provisional law called Civil Code 1632 that if you primarily negotiate a lease and other types of documents in other arenas, you need to provide documents in Mandarin Chinese. I know CAREA has them in Chinese. Similarly, if you were to be a landlord that speaks in Chinese with a Chinese tenant that wants to enter into this relief program under SB 1410, that agreement itself has to be in Chinese. So it wasn't on my slides, but it's something else to consider why you would need an attorney to advise you and to make sure that, I would hope CAR or maybe the California Apartment Association would come out with forms in various languages that have the right boxes in the various languages so that you don't violate that provision. And why is that significant? That if you entered into an agreement where you were in English, even if you thought it was the best deal in the world, otherwise comply with the law, the tenant could set it aside and get attorney's fees and get you in trouble for not negotiating in the language that you're speaking. That applies to Tagalog, Korean, there's a few other languages, Spanish certainly, but primarily for the Chinese American Real Estate Association, it certainly applies to Mandarin Chinese.
Thank you, Dave. That's a great point to bring up. I'm actually going to switch our slides back to our the future.
Okay.
And
yes, that's good. That's a good one. Thank you, Michelle.
Yeah, that way everybody can kind of, it's a little bit of a recap. Michael's asking, how about San Francisco? If a tenant wants to rent, to have rent reduced due to COVID and unsure of job situation, etc., can that be done with SF rent control? And can the rent be raised back up to the original rent when COVID is gone and market is back to normal with SF rent control?
I don't have a facility enough in San Francisco rent control to drill down on that specific question. It's beyond the scope of my presentation, sadly. I would consult with the San Francisco attorney that deals with landlord and tenant. It's so arcane, the rules there. My general answer is probably not, just because it's San Francisco, but I'm not going to venture a guess here.
Dave, would you have a recommendation or an attorney friend in San Francisco that you could refer?
I don't, but I'm sure there, if you go find law or find lawyer or whatever, you'll find a number of attorneys that just practice. In fact, I know that most landlord-tenant attorneys will only practice in San Francisco because it has its own. It's been one of the early vanguards of rent control, and has been very aggressive in tenant protection. So I don't have a name right here.
Okay, no worries. Michael, if you have any questions and you need an attorney in San Francisco, reach out to maybe one of us at the CAREA boards, and then I'm sure we can put you in touch with somebody very reputable. Stanley is asking, what can a landlord do if a tenant claims he cannot pay rent due to the impact of COVID, but refuses to provide any documents to prove it?
Well, as I said, they can, under both Alameda County and Santa Clara County, they can refuse to do so. In Alameda County, you may just get away with a tenant sending under penalty of perjury, saying I've got COVID relief, and under the Alameda County ordinance, that's enough. In Alameda County, the obligation to provide documentation is 45 days after the landlord requests, you can request it, or 30 days after the Alameda County ordinance is lifted, whichever is later. So if you're a diligent landlord and you wait until the moratorium is lifted and say, well, maybe now I can ask for the documentation, and you go ahead and do so, you've just extended to 75 days the period of time where the tenant has to provide it. In Santa Clara County, again, I showed you the form where documentation wasn't required at that time. I would imagine, again, if a tenant shows the documentation as a defense, as an affirmative defense, I don't want to sound like an attorney, but when you have a lawsuit, the tenant files an answer. The tenant has certain defenses it can raise, and one of the defenses it would raise is says, hey, I told him I was COVID, I couldn't pay rent because of COVID. They could show documentation in the course of the lawsuit at that time to provide a defense. And even under AB 1436, I think this is quite disruptive by not imposing these things in a time frame. It only is going to increase litigation, not decrease it. A tenant at any time before judgment in an unlawful detainer trial can show that he's entitled to COVID relief. So he can refuse, and then right before the judge says, I'm going to rule in favor of the landlord or the jury, you can have jury trials, and before the jury reaches a verdict and judgment's entered, the tenant, 5 days into a very lengthy trial can say, here's my documentation, judge, and if it's verifiable, the eviction is, the judgment is not entered. So, or if there was for some reason, a default judgment under AB 1436, it becomes law, and before there's the writ of possession issued to the county and it's executed, the tenant can go into court and get it stayed and say, have the judgment set aside, saying, I'm sorry, there's a default, here's my documentation, I'm eligible for COVID relief. So refusing documentation is not something that you should think, oh my God, now I've got a clear path to evicting a tenant. It's a speed bump for the tenant, and the tenant will have a lot of off-ramps to be able to show the documentation at a later point in the process to avoid an eviction.
Got it. Thank you, Dave. It just sounds like, on top of everything, what else can the landlord do besides being just open in communication? Is there anything else in terms of steps that they can take if, let's say, their landlord is not being communicative to them, with them, and hoping to reach an equitable solution? Like, what would be some of the next steps that you would recommend?
Well, if it's SB 1410 or AB 1436, it's really set by statute. It really removes a level of negotiating and freedom of contract that you would have. You do have an opportunity under the local moratoriums to negotiate a payment plan that may be more tenant favorable than what these moratoriums allow. So for example, in Santa Clara, I like to think if I were in an ideal situation, let's say you've been a landlord, you've had a tenant that's paid rent every time on time, every month for 5 years. And the first time that they're late or pay partial or don't pay at all is during COVID. I would treat that tenant as gold, because that person honors his or her commitment to pay rent. And I would work with that tenant to try to extend the repayments out, maybe even rent forgiveness. If that person comes back to work, then you, at that point, institute rent at the former rates. You don't want to lose that golden tenant who's fallen on misfortune during COVID because of COVID, to then somehow trying to figure out ways of evicting that tenant. And even if you succeed, then you're now dealing with an unknown person with a new tenant, even if their credit may appear good. You have a 5-year track record. Value that tenant. You've got you want to preserve that relationship. And I would approach the tenant this way, on the assumption that they're going to be working in good faith and not simply taking advantage of COVID to try to cut corners. If you've had a tenant that has been spotty with a record in the past, it's going to be more problematic. But again, given the costs, the risks, the delay in trying to evict anybody right now, we'll have a better idea how to answer that in October, when we know which rules are in effect at that time.
Got it. Thank you, Dave. Okay, so we have one from Lucy that says, what's the cost of evictions if you decide to sue? It's a tricky one.
Oh, well, it depends. I mean, I will typically take a $2,500 retainer, but if you have a jury trial, and there's tenant groups in Alameda County that are free to the tenant, that will invoke their right to have jury trials. Let's say it's a 5 to 6 day trial. Well, my hourly rate at $300 an hour, that's 8 hours a day. That's $2,400 times 5, and think of all the trial preparation before that. You can easily spend $15,000 on an eviction if it's contested. So, there are some attorneys, that may be on the low end in terms of estimating what it is, and then suddenly the tenants are surprised. The landlord clients are surprised at the bill. It's a very good question to have, but I guess the silver lining may be there's not much for landlord attorneys to do if both AB 1436 and SB 1410 pass in terms of going through the eviction process. But I really do think that when you asked earlier, should you involve an attorney, getting an attorney involved in the negotiations with the tenant and trying to do an agreement that is valid and enforceable will save you money in the long run, because if you do it without an attorney, you do it wrong, you may be in a situation where you have to go into court more than once because it gets set aside because you didn't follow the right rules on giving the proper notices to the tenants before trying to terminate.
Thank you, Dave. An attendee is asking, can a landlord report unpaid rent to the credit bureau?
No. Well, okay, let me know in this sense that if AB 1436 passes, that's explicitly prohibited. Right now, I would not do so if you're in a moratorium. They don't explicitly address this, but there are general provisions in a lot of the moratoriums saying that you shouldn't retaliate. You shouldn't retaliate against a tenant by trying to shut off utilities. Or I would think reporting somebody to a credit bureau itself would be considered retaliatory, and you just don't want to go down that path. What advantage does that make you get rent the next month? Does that help you get rent? No, if anything, if they're trying to apply for loans or trying to get back on their feet, it makes it more difficult for them. So it might give you a cotton candy sugar high in the moment, but you're really not helping out the tenant and undermining your own ability to collect rent in the future.
Thank you, Dave, for sharing that. I thought that was very helpful. Diana's asking, do you see a major backlog in eviction lawsuits?
Well, I guess lawyers like to say it depends. If these, as AB 1436 and SB 1410 go into effect, no, because you can't evict at all. But at some point, there's going to be an opportunity. There's going to be an opportunity for landlords to go into court. And yes, assuming, I mean, this is all dependent upon the state of emergency and the COVID. This is the black cloud hanging over us. So the COVID's lifted. There may be that period of time where we're transitioning to pre-pandemic activity. The courts now are open, but the resources are limited. We can't go into court as easily. There's electronic filing. The clerks are not, because of state revenue, there's been cutbacks. So the very processes by which you could go to court are going to be backlogged incredibly. And so, yes, there'll be a huge backlog at some point. When, I don't know.
We have one last question, but if anybody has to leave, because I know we're right at 12 noon, I want to be respectful. Just know that this is being recorded. Stephen's also asking if there's going to be another presentation. Yes, we're going to get and invite David back again in about a month or so after a few more, would you say maybe by the end of September or possibly October?
I would say October, unless for some reason on September 5th or 10th, everything passes and the governor sets everything into motion and extends the September 30th deadline. We may have a clearer picture in early September, and then we'll try to set it up sooner. But at this present time, I don't think the dust's not going to settle as of now until early October.
Gotcha. Thank you. We have one last question. It just popped up. It says, there's so much help for the tenant. Will there be help for landlords? And are there pro bono lawyers for because of COVID?
There may be, it's not me. No, seriously, there are very few pro bono attorneys for landlords. There are for tenants only because there are government grants and other funding mechanisms to be able to afford the bank of attorneys that all they do is represent tenants. They work together as a firm, essentially, in coordination with each other as attorneys. This is time consuming. There's a lot of detail, and our time is valuable. And I think one of the important lessons is that you really should value the time of an attorney. We are trained to understand the law. This is a high degree of complexity. Even for those of us that have been practicing for 30 years, like I have, these new layers of regulations and laws are difficult to follow and difficult to follow correctly. So trying to skimp and looking at a budget on what it means to be a landlord and say, well, let's just have a lawyer for free and maybe we'll cut costs here because I'm not getting rent is really not the way to approach it. Because you could theoretically, under worst case scenarios, I'm not saying that's likely, but I mentioned Alameda County, you could get prosecuted, you could get fined. There are fines that can happen even in a civil proceeding that can come against you. Not only that, plus the ability of the tenant's attorney to get attorney's fees against you. That if you're thinking on the short end, how can I cut costs by cutting out the cost of an attorney? That really is the wrong approach. I'm sorry, respectfully would have to suggest. One thing I should mention that I didn't mention before, there are carve-outs for evictions even under AB 1436, which is very similar if you've seen any of my past presentations when I was talking about the California Judicial Council exceptions. If your tenant is destroying his property, if the tenant is engaging in a public health and safety risk, like for example, running a meth lab or house of prostitution or doing something that is really out of bounds, you can go in and evict that tenant. It has nothing to do, so the balance at that point is we don't care if we're going to displace that tenant because they're engaging in criminal activity or property damage. We're not going to protect that tenant. But for everybody else that is eligible under COVID, we're going to close the door to you.
Thank you, Dave. I know quite a few of us have to leave, but I wanted to put one last thing out there for everybody. Dave, previously we were discussing about, can we just talk really briefly as to why a landlord would want SB 1410 to pass, and what that means specifically to landlords or maybe our clients who own rental properties?
Right. Again, if you're a qualifying landlord, there's a distinction between whether you have, if you're an individual borrower, if you operate as an entity, there's limited protections there. But first of all, it's not mandatory. Okay, so you shouldn't be opposed to it, because even if it passes, it doesn't require you to do anything. So then you can make the economic choice with your tenant after advising your CPA, consulting with your CPA. Does it make sense? And where it would make sense is, instead of trying to collect rent now, you can defer income between January 1st, 2024 and January 1st, 2034 in the amounts of the deferred rent that you deferred during this period of time. And even if the tax break exceeds your income tax at the state level, there's a nice provision that you can carry that tax break to the next year. So there may be some tax advantages. Also, you enter into a market where you might be able to sell your tax credits. Now, it may be pennies on the dollar, but there may be some immediate benefit. You don't have to worry about having all of the reporting requirements, and somebody else takes it over, and it'll be monetized that way. One thing about SB 1410, however, is that the tenant has to agree. Okay, so the landlord may think it's a great deal. For some reason, the tenant says, I don't care if I don't pay rent I want to pay rent in full during the COVID emergency. Or if the tenant doesn't answer and you can't get a hold of the tenant, you can't take advantage of it unless you have a written agreement. And then there's even layers of complexity there, that if you've got 2 or more tenants in your property, you have to have each tenant sign it. So if you have 2 or more owners of property, you have to have both owners sign it. So that you're going to have these forms that are generated or customized to follow SB 1410 that follows the rules. But I do think at least there shouldn't be any reason why you'd oppose it, because you don't have to do it.
Thank you, Dave. Okay, I'm going to close us up now. Here's David's information again. I wanted to also thank everybody for joining us today, and a special thank you for David for being our speaker. Feel free to reach out to us if you should need anything, and we look forward to having you with us next time. Take care, everyone.
Thank you. Thank you, everyone.